Good morning, good morning, good morning, good morning. Listen, I've got some, uh, as I said to you all yesterday, I was going to go over today the memorandum of motion from Diddy for his case to either he be acquitted or he gets a new trial. It is 62 pages, and we are definitely about to get into it. But first, copyright disclaimer under Section 107 of the Copyright Act of 1976. Allowance is made for fair use for the purpose such as criticism, comment, news reporting, teaching, scholarship, education, and research. Fair use is a use permitted by copyright statute that might otherwise be infringing. Let you know, trigger warning. There's going to be some instances in this live stream where there may be talk of DV and SA. If you or someone you love needs help, uh, the National Domestic Violence Hotline is 1-800-799-7233, and the SA hotline is 1-800-656-4673. Also, the views and opinions expressed in my videos represented are my own thoughts, concerns, and analysis. I don't know these folks or persons, and personally in my life, and my opinions are not a statement of a fact. It's alleged, alleged, alleged. All right, we got all of that good stuff out the way. How y'all doing? Y'all tell me. If you hear it, these are my fans that are whirling. I got this one whirling. I had this one is for my face, and that's sad. And then I got one because my poor little air condition. She doing the best she can. I mean, it's not sweltering in here. It's just cool, but I've got her on the lowest set, and it's still not cool. I think she needs a tad bit more Freon, but right now we're just gonna do what we got to do. All right, people. So we are about to read this. I was going to read it yesterday, but I couldn't. I remember I told you I had a lot of phone calls. I had a death in my family, so we were trying to make some types of arrangements, and those arrangements have been made. So let me add this to the stage. So this is the United States District Court of the Southern District Court of New York. It's the United States versus Sean Combs. Now we've seen that case. That case went on for for a good 6 to 8 weeks of our lives, and he was found guilty of 2 counts of the Mann Act. And I read yesterday that he was wanting to get bail, and this was he made like 3 or 4 attempts when he was charged, and the judge denied it. Then after he was convicted, he made an attempt, and the judge denied it. So this is his second attempt to make bail before his sentencing, and so he's made that attempt. So adding to that, he has proffered, let me get to there, a memorandum of law in support of defendant Sean Combs' renewed motion for judgment of acquittal, or in the alternative, a new trial. So they have the table of contents here. So we're going to be going over this whole document. Procedural history, the history of the White Slave Traffic Act, which is the Mann Act. They talk about the legal standards. They're going to go over the argument. All of this information we're going to go over to the conclusion. Like I said, this thing said it's 62 pages, but it probably has some addendums, and we'll definitely go over that. So let's get into this. And as you all are coming in, make sure you all hit that like button and subscribe. I have memberships available, and if you would like to give me a super chat, I'm amiable to those things as well. I think my Cash App and Venmo is rolling around the screen if you would oblige. It really does help out the channel. So let's so he spends about 4 or 5 pages just talking about all the statutes and stuff like that that they're going to be addressing. So this is what all of this is. Here we go. Are y'all ready? And let me refresh this docket real quick. Give me one moment. There's something been added to the docket, y'all. Okay, so let me just go over this thing really, really quick. You remember yesterday I read the memorandums from both the defense and the prosecution. And so you remember the prosecution turned in a letter which was very detailed as to why they but there was this point right here, and it says, but the defendant's suggestion that he went several years without inflicting violence on another person simply is not true. The defendant did engage in several acts of violence between 2018 and 2024. And then they go over this particular violence that they had. Now, this is supposed to be the violence that was placed on Gina. Because you remember one of the personal assistants talked about how he witnessed Diddy throwing apples at the woman. And since she didn't testify, since she didn't come in, all those witnesses that were around for her, they were not added. And it says, although this evidence was not presented at trial, the court is free to consider in assessing the defendant's dangerousness, right? So this was on page 10 out of 11 pages, right? So the judge just added, it says here, by August 4th, 2025, and I'm reading this little section right here, the government should further explain the need for redactions here, given the use of pseudonyms in the unredacted version of the letter. And so order. So they have until August 1st. So that's what the update is about that. So we won't go any further into that, but I did want to keep you all up to snuff on what's going on. So here we go. Let me see. Do I have enough water? Hopefully this shouldn't take but an hour. All right. All right, y'all ready? Let me make sure if this is the best one. There. All right, here we go. All right, here we go. For real now. It says since the government arrested Sean Combs last September, it has painted him as a monster. For months, prosecutors accused him of running a 20-year racketeering enterprise and ex trafficking multiple women. But his 2 month trial showed that these charges were not supported by credible evidence, and the jury rejected them. Mr. Combs now stands convicted of only two prostitute counts under the Mann Act, which doesn't require proof of coercion, threats, or fraud. The government told the jury it had to convict so long as Mr. Combs arranged for a longtime girlfriend or a paid male escort or entertainer to travel across state lines to get together and have the smacks. And that is all the jury convicted him for. To our knowledge, Mr. Combs is the only person ever convicted of violating the statute for conduct of anything like this. It is undisputed that he had no commercial motive and that all involved were adults. The men chose to travel and engage in the activity voluntarily. That may be true, but the Luciano, the money was exchanged, or am I missing something? The verdict confirms the women were not vulnerable or exploited or trafficked or SA during the freak-offs or hotel nights. And Mr. Combs never had intimate relations of the physical kind with the supposed prostitutes. We are aware of no other cases in which a person was convicted under 18 USC Code Section 2421A, even though he made no money from the prostitute, didn't have X with the alleged prostitutes, and didn't arrange the transportation with the intent of committing SA, trafficking, or an X crime involving a minor. Indeed, under long-standing Department of Justice policy, Mann Act charges are not filed in similar circumstances. In short, this conviction stands alone, but it should not stand at all. First, application of the Mann Act in these circumstances is unprecedented. Construing it to reach Mr. Combs' conduct would raise serious fair notice and discriminatory enforcement concerns. And and I won't go over them. I'll just note that they're here. These are the cases that they are referring to. Discussing Supreme Court precedents requiring narrow construction to avoid vagueness and ensure leniency. Is that lenity? Prostitute is not defined in the statute. It is normally up to states and local localities to regulate and define the prostitute or not. The term has had multiple different meanings over time, and depending on the jurisdiction, and in the 2000s, multiple state courts have held that paying for voyeurism to watch other people engage in the intimate relationships of the physical kind is not prostitution. So they're basically saying that he watched. He didn't engage, he watched. And once all of that was over and the people left, him and his girlfriend then engaged in consensual sex. Now, I will say this overall, and this is the way I feel. I think that because of the history of this act and what this act was supposed to protect, and let's be very, very clear, this act was supposed to protect uh, young white girls and white women So it was like a morality test at that time, because you remember back in the 20s, they had a lot of morality legislation, even with prohibition. That was morality test about the drinking, and then they had this morality because the way they looked at it, they didn't want you to smoke, they didn't want you to drink, they only wanted you to go to work, get married, have children, and for the men, get married, have children, and go to work. For the women, have children and take care of the home. They felt like that was that. Now understand and be very clear. During the industrial age, that is what society. That's what they deem to be the best for society. That the only thing that you should be doing is in a society. This is where we get the two. It's best for society for the person they have at least 2.5 children. So they're and they really, well, at that time they said four. They want two children to replace the mother and the father, and then two extra children. Heirs and spares. But for the working class, because at that point there was no middle class, you were either rich or you were poor. The middle class didn't start pulling through till after World War II, because that's when the white vets were able to come in and take advantage of VA loans and housing and suburbia. That's when suburbia and all that stuff started happening. So they were able to take advantage of that. Now, the thing about this Mann Act is this. The thing about this the Mann Act that I think that needs to be done is, it seems like there should be phases of it, or different severities of it, because if you're transporting people for the prostitute, and you are it can be shown that it is a commercialized business. That should be one part of it, and there should be a sentencing guideline for that. But again, and I've told you all earlier in any of my broadcasts in regards to y'all getting flued out, you could be violating the Mann Act. And that is because how vague it is. Now, the Mann Act has not upgraded from the morality of the times. It doesn't say, with the morality of the times, da 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 da. It's saying that these things are immoral. And anyway, let me just clear up. Basically, all I'm saying now, I don't mishear me. Please don't mishear me, because it is my opinion and the opinion of Pam Entertainment TV. Diddy is not a good guy. Diddy is not a good guy in my opinion. Diddy is manipulative. Diddy is ruthless, and all those things are possibly good traits in business, but as just a person and a personality, it's not. His ego has gone unchecked. I'm not here to talk about his sexual life, because like I said, there are different levels of freakiness, and everybody has a different level of freakiness. And I'm not here to discuss that. But what I am saying to you is this man, when he wants something and how he wants it, he takes every means necessary to get it, even if you're talking about violence. And he has no issues and problems with that. Whatever it is you feel about Cassie, whatever it is you feel about Jane, whatever it is you feel about Gina, whatever it is you feel about Kim Porter, whatever it is you feel about any of these women. Because I know y'all like to tussle in the streets. And because of their sexual proclivities, there's a level of and their approximation to different men. You all like to tussle in the comments about what a woman deserves because she acts this way or that way. Regardless of what you think about it, even the lowest of the low does not deserve to be beat down to the ground, have their heads pushed in between the washers and dryers. And I know there are some women who are just as abusive to men. Same thing. See, we grown over here, and so we're not gonna act like kids and be like, well, the girls do. We're not acting like that. I say what I say. You also know that it flips and it switches regardless of what your sex, what your gender is. I don't care who you are, how you identify. You have no business putting nobody's head through the washer and dryer. No, as Keith Sweat says, nobody. But let's continue. The lack of statutory definition, the changing and inconsistent ordinary meaning of the term, and the facts most states where the actual activity occurred did not treat this conduct as prostitutu creates a classic trap for the unwary, requiring a narrow interpretation that would not sweep in Mr. Combs' conduct. Now, I would agree that he is not engaging in the intimate relations with of the physical kind with other people. I can concede to that. But he was setting up the arrangement so that that could happen between uh Cassie and Jane. They were setting those things up both equally. Jane and Diddy, Cassie and Diddy. They were calling the agency to get the people. Once they got the people, if they enjoyed the people, they would then make arrangements to call and have the people come themselves. They were paying these people in cash. And we're not going to be odd and we're not going to be obtuse. That money was coming from Diddy. Why do I say that? For Jane, he was paying for everything. Calls were made. They showed that calls were made to the assistants to bring the money over. It wasn't odd for him to have thousands upon thousands of dollars on his person. There's nothing illegal about having that kind of money on your person. I think it's foolish to have that type of money on your person. However, I don't roll like those people like that. But we do see that there was money exchanged for all of this. And so I think he has some culpability in regards to that. But I will continue. Again, I am not a lawyer. I'm just someone that loves to read and go over all of this stuff and give my opinion. The lack of statutory definition, the changing and inconsistent ordinary meaning. Did I read that? Yes. Here we go. Creates a classic trap for the unwary, requiring a narrow interpretation that would not sweep into Mr. Combs' conduct. And they go over Snyder 603 U.S. at 15. The statute should apply only to defendants with a commercial motive in the prostitution, or if it can apply to consumers of the prostitute, should not cover consumers who do not have the intimate relations of physical touch with the adult prostitute. Such a limiting construction is also required to avoid other serious constitutional problems of substantive due process, the First Amendment, and federalism. Mr. Combs, at most, paid to engage in voyeurism as part of a swinger's lifestyle. That does not constitute prostitutu under a properly limited definition of the statutory term. Second, if prostitution includes a defendant who pays to observe two other people to have sex with each other, the evidence was insufficient to show that Mr. Combs had any such intent. I think the payment part is where I'm looking at that this might be an issue. It's the payment part. Because once you paid that escort to have sex, regardless of who that person has sex with in the room, he has been paid to perform that. And that is a commercial act. Because I'm willing to bet you ain't paid no taxes on. Let me hush. I don't know that to be true. The proof at trial showed that he typically hired the services of male escorts or dancers, advertised openly through lawful businesses, that the men were paid for their time, and that they enjoyed the activities and had friendships with Miss Ventura and Jane and were not merely traveling to have sex for money. But that was not true because everybody testified that that's what they were there for. You Diddy is paying a lot, Diddy is paying a lot of money for this word salad. This is some very expensive word salad. Third, if the statute is interpreted to cover Mr. Combs' conduct, his conviction must be reversed because it violates the First Amendment. The freak-offs and hotel nights were performances that he or his girlfriends typically videotape so they can watch them later. In other words, he was producing amateur pornography for later private viewing. This is protected First Amendment conduct that no substantial government interest justifies prohibiting, since the films depicted adults voluntarily engaging in consensual activity. Baby! And this is what you have with the big bucks you pay these lawyers for. Basically, he's saying is that Sean Combs was writer, producer, and director of films of amateur PORN and that he was just flying the people in because they were now considered to be actors. Is that what? Okay. So with that logic, my question is, if you're doing all of that, are we saying that these people were your employees? Contract workers? What are we saying? Is that what we're saying? Were there contracts written for this? For the people that you hired? Were there auditions? Because that's what I'm assuming. I don't know. I don't work in that industry. I'm assuming that there's a whole lot of stuff that goes into that. Okay, Puffy. Fourth, if the court declines to grant an acquittal, a new trial is required under Rule 33 due to severe spillover prejudice from reams of inflammatory evidence. This evidence, particularly the intercontinental footage, was admissible only because of the RICO and the ex-trafficking charges. It would never have been admitted at a trial solely on the Mann Act counts, as it was irrelevant and unfairly prejudicial. Under the Second Circuit's retroactive misjoinder doctrine, a new trial limited to evidence admissible to prove the Mann Act charge is warranted. Sean Combs sits in jail based on evidence that he paid adult male escorts and entertainers who engaged in consensual sexual activities with his former girlfriends, which he videotaped and later watched with the girlfriends. This is not the prostitute, and if it is, his conviction is unconstitutional. the court should grant an acquittal or an absolute minimum a new trial. On June 24, 2025, after the government rested, Mr. Combs moved for a judgment of acquittal on all counts under Rule 29. The court reversed the decision. And so this is the transcripts that they're referring to. The cumulative word count of the single memorandum of law, which covers both Mr. Combs' Rule 29 and his Rule 33 motions for the sake of efficiency, is less than 2 times the limit the court's individual practices. And that's interesting to me because I've seen this several times, and I've seen this with the prosecution's information, that when these lawyers are writing these things, they have a word limit, they have a page limit of how many words and things like that they can use for these documents. And I think that's good because that's really great for efficiency. They're not out here just saying so much that they are keeping them succinct and to the point. I'm willing to bet you that had to do with the judge receiving 7,000 pages of rebuttals and stuff like that, and it was clogging it up because the judge couldn't read all that information. On July 2nd, 2025, the jury acquitted Mr. Combs of the most serious charges. The jury found that he was not guilty of the racketeering conspiracy charge in count 1, and he was not guilty of the trafficking of Cassandra Ventura as charged in count 2, and not guilty of the trafficking of Jane in count 4. However, the jury convicted on counts 3 and 5, which charged that he knowingly transported, aided, and abetted, and willfully caused the transportation of multiple individuals, including but not limited to Ventura and Jane, respectively, and commercial ex-workers in interstate and foreign commerce on multiple occasions with the intent that they engaged in the prostitution in violation of 18 U.S. Code Section 2421A. This motion renews and supplements Mr. Combs' early rule. Now, the thing about that, oh, well, I was just a voyeur, I didn't participate. You know, when they talk about the trafficking of women, those people that are trafficking, they're not known to be participating in it. They're known to be transporting the people from one point to the other point so that they could do that. They may not necessarily have relations with the people that they are transporting. So let's continue. All right. This motion renews and supplements Mr. Combs' earlier Rule 29. So this is the second motion that they put up. The first one was denied when they were in court. The history of the White Slave Traffic Act, and this burns me up because they made sure to say white slave. Now, you know, this country didn't have problems with the slavery if your color was a little darker, but this is definitely to protect that social construct of whiteness, and particularly those women, because at that time, again, there weren't that many laws that were protecting of women and children at that time. And anyway, let's continue. The original purpose of the statute was targeting commercial traffickers. The White Slave Act of 1910, known as the Mann Act, has a troubling history. As described in Mr. Combs' motion to dismiss, docket 153, the statute had racist origin. It was born out of a hysteria that white slavers were preying upon young women, coercing them into prostitution through threats, intimidation, and force. And that's United States versus Flukas 22 F 4th. We're not going to go all over that. One of the bill's backers claimed that American born girls from good homes were being tricked into prostitution and then sold to all men who could pay the price. Young men, old men, clean or unclean, healthy and diseased, black or white. But even with this odious history, the statute was never intended to apply to the sort of conduct for which Mr. Combs was convicted. The act was only intended to apply to men who acted with a profit motive, coerced women into some of the forms of the X trade, aka slavers, equivalent to aka pimps in modern parlance. Legislative history shows the act was restricted to professional procurers, and they note 56 Yale LG, this is what they note. As Representative Mann described in his report to Congress, the legislation is not needed or intended as an aid to the states in the exercise of their police powers in the suppression or regulation of immorality in general. It does not attempt to regulate the practice of voluntary prostitution, but aims solely to prevent panderers and procurers from compelling thousands of women and girls against their will and desire to enter and to continue into a life of prostitution. Similarly, Representative Sims describes how slavers imported women for profit. Now, what is the man procuring this woman for? What does he take her from one state to another for? What purpose does he bring her from a foreign country? To make money, in order that he may have a few dollars put to wait a minute. In order that he may have a few dollars more, have a few more dollars to put into his unholy pocket. Confirming statute's purpose was to eliminate the white slave business, which uses interstate and foreign commerce as a means of procuring and distributing its victims, and to prevent pandering and procurers from compelling thousands of women and girls against their will and desire to enter and continue in a life of prostitution. The act became a tool for selective enforcement of moral standards. Although the statute was enacted in response to a popular outcry over an alleged problem of kidnapped women and coerced prostitution, until the 1960s and 70s, it was abused by law enforcement. Federal prosecutors selectively deployed the act to sexual activities between consenting adults because a large constituency in the form of church groups, purity organization, and moralists applauded the imposition of federal coercion to advance their vision of proper conduct. Remember, I told you they had a whole big swath of that. That's how we got prohibition. That's how we got the Mann Act. It was a lot of other different laws, things like that. That's how they had the laws segregating the sexes. That's how they had, they didn't believe that segregating the races. They didn't believe that it was moral that, like black people marry white people and white people marry Asian people and all this. They didn't believe that that was moral. They believed that those things were immoral acts. There's a whole lot of things. And if you look at how the country is going into now, they're trying to get back to the same thing. That's why it's so important that you all read and understand what your history is. And I know a lot of people like, well, I saw it online. Going online is fine, but I would also encourage the lot of you. There are public libraries in every area. Go look it up and go look it up in a book because that's physical form. What we have been finding out with this increased usage of AI is that internet information can be easily manipulated. This is why all of a sudden they're getting you to try to believe in this Mandela effect and all these different things didn't happen. Like they talked about, with the fruit of the loom and the cornucopia and the fruit of the loom. I don't think that there's anybody unless it's sitting in a attic somewhere in a trunk. I don't think anybody has underwear and t-shirts from the 1970s and the 1980s right now. I just don't think that anybody has, because underwear usually doesn't last that long. And so they're counting on the fact that you don't no longer have physical copies. And note that this quote unquote Mandela effect is a modern effect. Because again, it's trying to explain it says it's trying to explain phenomenons that people remember certain things that didn't happen. Because apparently this effect started that a lot of people believe that Nelson Mandela had died back in the he died while he was in prison. But how could he when he went on to be the president of South Africa? So I would just tell you this, because this is why you saw Florida and all these places. They do this under the guise of DEI and all this other stuff, which I don't disbelieve that they're doing. But anytime they do anything overtly, there is a covert reason, and the covert reason is they don't want you to understand and know that this has happened before and it failed. And so they're giving you this information to show you that, oh well, we're going to do this. This is leading. No, it's the same stuff. It's the same stuff. This is why it has been written, and it is so important there be a separation of church and state. Because again, the religious rules are written by man. They tell you it is the infallible word of God, but these are written by men, but at least anywhere from 75 to hundreds and hundreds of years after the event happened. So unless there was some kind of information that you could see at that point written by Jesus, there's just something that's written by Jesus. These are all interpretations of an events that happened. All right. Two early Supreme Court cases endorsed this overbroad view of the original version of the statute and ignored its clear history and legislative intent. To extend it to non-commercial interstate transportation, Caminetti versus the United States, here is the cases that they're talking to right here, Cleveland versus United States. The government may rely on these cases to defend the conviction here, but their rationale has been repudiated by subsequent amendment to the statute and the Supreme Court cases. In Caminetti, a divided court confirmed convictions of defendants who transported women across the state line so they can become their mistresses and concubines. The majority rejected the argument that the statute was intended to reach only commercialized vice. Employing moralistic language, the majority held the defendant's conduct was covered by the immoral purpose provision that contained in the act. To say the contrary would shock the common understanding of what constitutes an immoral purpose when those terms are applied as here to sexual relations. Caminetti held that the word prostitute should be given a broad scope covering general sense of immoral and promiscuous sex, regardless of whether it was for hire. There can be no doubt as to what class was aimed at by the clause forbidding the importation of alien women for the purpose of prostitute. It refers to women who, for hire or without hire, offer their bodies to indiscriminate intercourse with men. The Caminetti majority thus interpreted the act to cover anyone who transported a woman across state lines for extramarital sex. Justice McKenna, joined by Chief Justice White and Justice Clark, dissented. He noted the statutory text was ambiguous. It covers anything done with an immoral purpose, which could cover conceivably a vast amount of behavior, so it had to be limited by some judicial construction. If it be admitted that it is limited at all, that ends the imperative effect assigned to it in the opinion of the court. As some limitations were necessary, the statute should be limited by its context necessarily and the purpose of the statute. Justice McKenna observed that Congress deemed the statute's title, the White Slave Traffic Act, particularly important. It is prominence, its prominence gives its prevalence in the construction of the statute. Relying on that title, combined with the clear legislative history, Justice McKenna concluded the act must be limited to commercialized vice, that is, immoralities having menacing purposes. Several commentators averred that committee and other similarly broad interpretations of the Mann Act deviated from its statute's purpose. 3 decades later, the court had an opportunity to reconsider the scope of the act in Cleveland, but in a more odious decision, another divided court extended the act to cover Mormon polygamists. The Cleveland majority reaffirmed committee holding that the act is not restricted to commercialized prostitution. Motivated by barely concealed hostility to the Mormon religion, the majority held polygamous practices were clearly immoral and therefore illegal. The organization of a community for the spread and practice of polygamy is, in a measure, a return to barbarism. It is contrary to the spirit of Christianity and the civilization which Christianity has produced in the Western world. Justice Rutledge concurred in the result. He stated Caminiti was likely wrongly decided, as Justice McKenna had convincingly demonstrated in his dissent. He expressed grave doubts about perpetuating the court's error, but as Caminiti had not been overruled, he acquiesced in the results. Justice Black and Jackson dissented. They stated affirmance requires extension of the rule announced in the Caminiti case, and the correctness of that rule is so dubious that it should at least be restricted to its particular facts. Justice Murphy also dissented and argued Caminiti should be overruled. Today, another unfortunate chapter is added to the troubled history of the White Slave Traffic Act. The consequence of prolonging the Caminiti principle is to make the federal courts the arbitrators of morality of those who cross state lines in the company of women and girls. Like Justice McKenna, he argued the statute must be limited to the prosecution of pimps and other purveyors of coerced commercialized sex. The result here reached is but another consequence of this court's long-continued failure to recognize the White Slave Traffic Act, as its title indicates, is aimed solely at the diabolical interstate and international trade in white slaves, the business of securing white women and girls and of selling them outright or of exploiting them for immoral purposes. Now, I just read that. Now, is it me? Or is this not helping your argument? Because clearly it said something about talking about men who take women for the purpose of sex, and these are people who they're engaging in immorality with because this is their mistresses. But we'll continue. Cleveland was also criticized. Let's get down here, because they're just going over all of this stuff. So it says here, subsequently, then Professor Ruth Bader Ginsburg co-authored a government study criticizing the Mann Act as, quote, offensive because of the sexual stereotypes it perpetuates, and argued that it also suffered from other constitutional infirmities. These prostitution proscriptions are subject to several constitutional and policy objections. Prostitution as a consensual act between adults is arguably within the zone of privacy protected by recent constitutional decisions. And they list a decision. The Mann Act suffers from additional problems. It prohibits the transportation of women and girls for prostitution, debauchery, or any other immoral purposes. And this is where I was telling y'all about getting flued out could land you with a charge from the Mann Act. This language, which is not confined to illegal acts, but encompasses immoral conduct as well, appears too broad and too vague to the point where fair notice of the activity prescribed is hardly supplied. Moreover, the prescription is not limited to situations in which there is a final financial factor. Thus, the act poses the invasion of privacy issue in an acute form. Congress eventually amended 2421 in 1986, but only in a limited way. It replaced gender-specific language, women or girls, with gender-neutral language with individual, and replaced the term debauchery and immoral purposes with any sexual activity for which any person can be charged with a criminal offense. Thus, the amendment replaced the original vague term debauchery and immoral purposes with an equally broad and amorphous category that depends almost entirely on the law of the state into which the transported individual travels in order to undertake the extra sexual activity. And it left the term prostitution, which also has different meanings in different states and local jurisdictions, as discussed in infra, entirely undefined. The DOJ has long declined to enforce Caminetti and Cleveland, given the intervening changes in both the statutes and the Supreme Court precedent. It is highly doubtful that Caminetti and Cleveland remain good law. In part for that reason, even before the 1986 amendment, the government itself has long declined to prosecute non-commercialized acts of mere voluntary prostitution. For over 75 years, the Department of Justice has stated that Mann Act enforcement should be limited to cases targeting defendants who violate the statute for commercial gain. And here where it is very important, because I know that changings of law and things like that or amending laws is all from Congress. And you all thinking that politics doesn't matter, politics does matter. Because the law does not clearly state for commercial gain, but it hasn't been, with the lack of better term, it hasn't been sexy for the DOJ to go for those cases, because again, a lot of those attorneys that are working in the district attorney's office, the cases that they usually take cases that they know that they can win. Those are the cases that they want to take. They don't want to take cases that are going to bog them down in paperwork and stuff like that. So I guess from what I'm reading, they're saying that this case is unusual because there was no commercial gain, and this is not the type of case that the DOJ has found sexy enough to take. Though they can. Now, don't mishear me. They can take those cases because the language still is ambiguous, and it does cover whether or not you all are getting flued out. Because if they're paying for your plane ticket, if they're paying for your hotel room, and they give you a little change, and you doing things that are a little strange, that violates the Mann Act. For example, the 1953 version of the U.S. Attorney Manual stated, The White Slave Traffic Act makes it an offense knowingly to transport any woman or girl in interstate or foreign commerce, or in the District of Columbia, or in any territory or possession of the United States for the purpose of the prostitution, debauchery, or for any other immoral purpose. Commercialism is not essential to a violation of the act. However, as a general rule, prosecution should not be instituted in the so-called non-commercial cases. Because again, those cases weren't high profile. Now, I think with Diddy's case became high profile, not just for the Mann Act itself. It became high profile because, again, that videotape of him beating down Cassie came out, and it exposed his sexual proclivities. Because you all have to remember, everybody at that point assumed that the freak-offs were commercialized, because we had lawsuit after lawsuit after lawsuit. We had lawsuit after lawsuit after lawsuit, talking about immoral acts between Diddy and all these different people who have filed all these different lawsuits. So everybody was thinking in their heads, because of how all of this played out, because again, we weren't very sure of what the essence of the freak off and the King's night and the hotel. We weren't very sure about that. We knew that there were escorts involved, and we knew that there were yachts involved. We knew that there were hotel rooms involved. And we formulated in our head that it started from those white parties, and you went from the white party, and then you went to the after party, and then you were invited to the hotel lobby, and from the hotel lobby you were invited up to attend all these different things. This is the way that the public thought about it. And this is why I've asked the question, I've asked it several times. How does this affect the other lawsuits that are pending? Now that, because I guess all of those, and do not mishear me. I am not telling you that the people who pulled these lawsuits have not been violated. I do not know. But I do know that there were several that were talking about, because again, we heard about the mood enhancers, we heard about the escorts, we heard about the hotels, we heard about all of those different things. And so a lot of those cases that I have read had dealt with someone being at a party. Either they were working the party or they were a guest at the party. They were given some type of illegal mood enhancer, and then there was non-consensual acts performed on them. And that is what the majority of those lawsuits are stating. Now, there are some other lawsuits that are stating other different things, but that is the majority of what these lawsuits, because that is what was told to us or that is what we as the general public assumed what these freak-offs and these hotel nights and these things like that were about. But now we're seeing that this was about two people in a relationship, two people in a toxic relationship that enjoyed one enjoyed voyeurism, the other one enjoyed having relations with other people and making this big performance, and they enjoyed having the relationships with other people, and it's supposed to be this big performance. Apparently Diddy was telling, okay, you need to, this is where you need to kiss, this is where you need to hug, you need to add more baby oil because I need to see the glistening and all this other stuff. You need to do this, you need to do that. So we see at this point in time that this is what this was. It wasn't snatching people out of the party or anything like that. So my question has always been, how does that affect how does that affect these other lawsuits? And that's all. That was all I was trying to get into. All right, let's continue. This policy of not prosecuting non-commercial cases continued through the remainder of the 1900s until the focus of the statute turned to cases involving minors and or trafficking in the 1980s. Thus, the 1961 U.S. Attorney Manual that stated prosecuting persons who are not engaged in commercial prostitution enterprises as panderers, operators of houses of prostitution, or call girl operations, and those who act for and associate with such persons should not be instituted without prior approval from the criminal division. And in 1966, the Attorney General flatly stated that the Mann Act is designed to provide those engaged in commercialized prostitution of the use of facilities of interstate commerce. The 1970s and the 1984 manuals continue to require consultation or approval from Main Justice for any prosecution of individuals not running commercial prostitute enterprises. But 1988 enforcement priorities shifted to cases involving trafficking and minors, yet non commercial cases remain deprioritized. Unless minors are victims, prosecution under 18 U.S.C. Section 2421 and 2422 should generally be limited to persons engaged in commercial prostitution activities, even though the commerciality is not an element of the offense. Prosecution of persons other than those engaged in commercial prostitution enterprises as panderers, operators of houses of prostitution, or call girls operations, and those acting for or in association with such persons should not be instituted without consultation with the General Litigation and Legal Advice section unless minors are victims. That directive continued through the most recent iteration of the U.S. Attorney's Manual. And today, the Justice Manual, which replaced the U.S. Attorney's Manual in 2018, makes clear the prosecution of customers involved in 18 U.S. Code Section 2421 offense, like Mr. Combs here, is now limited to prosecuting those who engage in commercial sex with victims of sex trafficking, in addition to those who otherwise perpetrate or facilitate human trafficking offenses. In short, since the mid 20th century, the government has itself recognized that cases should not be brought under the broad doctrine of Caminetti and Cleveland, and that Section 2421 should be enforced only where the defendant has a commercial motive, selling sex. Employs coercion where minors are involved. Here, in the absence of any trafficking charge, the standalone Mann Act counts would never have been prosecuted. Indeed, in its opposition to Mr. Combs' selective prosecution motion, the government suggested as much. All right. So what I'm going to do right here, we are at the hour mark. I am going to take a brief break, and I will return in probably about give me about a minute or two, okay? Thank you all so much. All right, we are back. It's sad, really. I'm a coffee tea girl, and it could be hotter than the devil's toes outside, and I still want a cup of coffee. And I do apologize because I should have made it before the stream, but I thought I was good to go. So let's get into this. The legal standards. On a defendant's motion or on its own, after the jury verdict, a court shall enter a judgment of acquittal of any offenses. So let me just go back really quick before we really get down into the legal standards. Because basically what they're saying is this. They want a new trial. And they want a new trial because they clearly want the new trial with the charges of just the Mann Act. Because they believe that with this new trial, or being acquitted, this wasn't a case that the U.S. Attorney's Office would put forth anyway. They are believing that because the U.S. Attorney's Office they used this case to kind of further the RICO case that they had. And again, the issue with the RICO case where I feel that people miss out on is the fact that I think it fell apart because they did not have Gina. I think that's why that case fell apart. Because number one, that meant that because they didn't have the Gina, they had to rely on Jane to put forth the trafficking charges, and they had to they laid it solely on Jane's foot in regards to the trafficking charges. Because if the jury would have believed that this was a continuous line of abuse, he would have been convicted on the RICO charges. But let's be very clear. Just because he was not convicted of those charges, it doesn't mean that the acts and things did not happen. It's just the fact that with a RICO charge, it is a 5-year window unless you can show continued abuse. But that abuse window broke when Gina was pulled out of the thing. She was the linchpin between Cassie and Jane. So when you look at all the people that were involved, even when you're talking about Mia, all of that stuff was weak. Didn't say it didn't happen. I'm not here to be that person. All I'm saying is there was a break in a gap between, 2019 and 2021. And that break in the gap was Gina. Gina was the linchpin. When they lost Gina, when you remember when the personal assistant said that he saw Diddy chuck apples at Gina. See, they had, he was there for Cassie and Gina. He wasn't there for Jane. So he could be able to talk about that. He was only able to put that information because of the fact of what he saw. But he didn't have anything to corroborate what he saw in regards to Gina. So, because like I've said before in all of my commentary, I believed Capricorn Clark, but Capricorn Clark wasn't going to get any justice unless that they could show that there was a continuous stream of infractions. But because there was a break in those infractions, I think that that's why they lost the case. And I know it sounds, Oh, well, Pam, there was all this other stuff. Yes, there was all that other stuff. Now, I don't know if the drugs, I don't know about that angle, y'all. But obviously, again, they needed that trafficking thing to go forward. Like I said, if they could see that Jane was trafficked and transported, he would have that RICO. They probably would have convicted him on the RICO charge. They didn't believe the trafficking, and they didn't believe the trafficking because of. And I'll be very real. I don't think that they believed it because of the fact that the girls were procuring the escorts as well. And again, Jane was the worst one to leave it on her heads because she attended a freak off of another person. So yeah, Jane, if the defense if the prosecution thought that their case was if they just had Cassie and they had that videotape back in the day, maybe. I don't know, because I think basically what they would have had was what they still would have just they well, I don't know. But Gina was the linchpin, whether people want to realize it or not. I think Gina was the linchpin in this whole thing. If you did not have Gina, you did not have that continuous motion. But anyway, let's continue. Let's get into these legal standards because I don't want to make this any longer than it needs to be. On a defendant's motion or on its own, after the jury's verdict, a court shall enter a judgment of acquittal of any offenses for which the evidence is insufficient to sustain a conviction. Although reasonable inference must be resolved in favor of the government, specious interference are not indulged. I hope I said that right. Specious. Okay. Nor are inferences based on conjecture or pure speculation. An inference is not a suspicion or a guess. It is a reasoned, logical decision to conclude that a disputed fact exists on the basis of another fact that is known to exist. But inference is not the same thing as speculation. Indeed, even reasonable speculation is insufficient. Where a jury's finding rests only on modest evidentiary showing, equivocal or attenuated attenuated evidence of guilt, or a combination of the three. Attenuated evidence of guilt, or a combination of the three. All right. Indeed, even reasonable speculation is insufficient. All right. In short, Where a jury's finding rests only on modest evidentiary showing of equivocal or intonated evidence of guilt or combination, there must be set aside. In short, the government must do more than introduce evidence at least as consistent with innocence as with guilt. The court may vacate the judgment and grant a new trial if the interest of justice excuse me, so requires. The test for determining whether Mr. Combs is entitled to a new trial based on the argument asserted in this motion is set forth in point 3 below. There was insufficient evidence that Mr. Combs transported anyone with the intent to engage in prostitution. Mr. Combs was convicted of knowingly transporting an individual in interstate commerce with the intent of such individual to engage in prostitution. The 2 counts of convictions thus requires that prostitution was the purpose of the interstate transport. The Mann Act does not define the term prostitution. A host of serious constitutional problems would be presented if the statute were interpreted to cover the conduct at issue. Performances in which adult male escorts and Mr. Combs' adult girlfriends engaged in consensual sexual activity while he observed. The evidence shows Mr. Combs experienced these persons not as a, quote, typical John, but rather as a voyeur who filmed the performances. To avoid these constitutional concerns, the statute should be narrowly construed to apply only to defendants who have a commercial motive. Now remember, that's not necessarily true, but they did present the information that the government, by their own manual, usually they usually do not prosecute cases that don't have a commercial spin to it, meaning that people are getting paid and profiting from the transportation. Alternatively, even if prostitution includes paying money to watch 2 other people have consensual sex, no reasonable jury should find the trial evidence sufficient to prove beyond a reasonable doubt that Combs intended to pay the escorts or entertainers for sex as opposed to their time. The Mann Act should be narrowly interpreted to avoid serious due process, First Amendment, and federalism problems. As explained in the 1986 amendment, eliminated the immoral purpose and debauchery language on which the Caminiti and Cleveland were principally based. Accordingly, although those cases have never been expressly overruled, their holdings that Section 2421 can be applied to defendants not engaged in commercial prostitution were effectively overruled by the 1986 amendment. That is true at least for purposes of this case, because the conviction was only for transportation with the intent to engage in prostitution and not the broader category added in 1986 of intent to engage in any activity for which any person can be charged with a criminal offense. 18 U.S. Code 18, Section 2421, Section A. In other words, the 1986 amendment itself means that Caminiti and Cleveland do not apply to this case and do not expand to the prostitution, with the quotation marks around it, clause to cover non-commercial activity by a mere consumer of prostitution services. But even apart from the 1986 amendment, effective abrogation of Caminiti and Cleveland, the statute should be construed not to cover non-commercial conduct by mere Johns, especially when those Johns do not even intend to have intimate relations of the physical kind with the prostitute too. And it goes on. Interpreting, so to avoid these distortions, the statute scope should be limited to defendants with a commercial interest in exchange for the money. So basically what they're arguing is that he didn't touch them people. He didn't touch them. He didn't do anything but watch. It wasn't him. It was Cassie. It was Jane. That's who did it. I just watched. I just paid him for his time. Now, if he wanted to jump off and do all that other stuff, hey, I just obliged him. I was cool with it. As long as she was cool with it, I was cool with it. So let's continue. Let's get to their second argument. Well, they do have under there a due process vagueness problem. To satisfy due process, a penal statute must define the criminal offense with sufficient definitiveness that ordinary people can understand what conduct is prohibited and in a manner that does not encourage arbitrary and discriminatory enforcement. The Mann Act does not define the term prostitute. That word has shifted meanings over time, and continues to mean different things under different state and local laws in the 21st century. And in multiple relevant states, it does not apply to voyeuristic conduct like that issued here. The failure of persistent efforts to establish a standard can provide evidence of vagueness. This underscores the serious fair notice and arbitrary enforcement concerns here, dictating a narrow construction. And they go on to think, I want to get to argument 2 because we basically understand what their argument is. And they're also arguing that when this law was enacted, we are now in the 21st century, and things that were considered to be immoral and debauchery are considered to just be fair play at this point. And they're going back to this. Specifically, a number of courts have held that prostitution is an individual paying another for sexual contact between the two, not an individual paying to view another have sex with a third party. Now, this is very interesting to me. So they're basically saying, yeah, he paid them, but he didn't pay to have sex with them. He paid to watch, to do whatever it is that they were going to do. Now, mind you, let's keep in mind, they initially said that he was basically a director of porn. PORN, excuse me. You know, with him directing how they do certain things, when they put the baby oil on, when they touch, when they kiss, all of those things. He's directing this. So would he not what is that is it Munchausen by proxy, where isn't that what it's called, Munchausen by proxy, where the mostly women will make their children sick so they can get the adoration or the emotional payoff from all of that, meaning people are feeling sorry for them, and then they're hugging and comforting them and giving them gifts and things like that, making them the center of attention. And the only way that they can get to the center of attention is if they continue to make their child or whomever sicker and sicker and sicker by whatever means they do that. So would this be prostitution by proxy? Would this be prostitution by proxy? He's not participating, but he is getting all the emotional payoff and feels and videos and stuff like that from it. I'm asking the question, y'all. Let's get down here, because they're going through a lot. They're going through a lot of cases. And like I said, we're not going to go through all of those things. We just want to hit the points. They talk about the substantive due process problems. The federalism problems. The Supreme Court has repeatedly invoked federalism concerns to narrow the scope of federal criminal statutes to avoid placing under federal superintendents a vast array of conduct traditionally policed by state. And so there are crimes that the federal government deemed to be crimes. There are policies and procedures that the federal government deemed that everybody follow. However, those other things that they don't talk about, they let the states do that. So if the states have a law in regards to prostitution and on criminality and stuff like that, they leave that to states. But let's go back up here to the part 3. Part of the rationale underpinned in some of the 21st century decisions holding that commercial voyeurism is not prostitution, whether stated or unstated, is a concern about avoiding serious First Amendment problems. As explained in point 2, applying the Mann Act to Mr. Combs' conduct would violate the First Amendment right, because they say that he has a right to view and look at what he wants to look at, privacy issues and all of that. All right. Here we go. Part B. Narrowly construed, the Mann Act does not proscribe Mr. Combs' conduct because he lacked a commercial motive and did not intend for paid escorts to have sex with him. And that has been the point that this is the biggest point that they're making. He didn't have sex with any of these people. It wasn't him. He didn't have it. If you were going to talk about violating the Mann Act, from what they're looking at, I'm looking at their argument. If they're talking about who is in violation of the Mann Act, it would be Cassie and Jane, because they were the ones, according to the escorts, that were physically paying them. I do understand. Again, I'm not obtuse or crazy. I do know that they got that money from Diddy. But they're saying they're basically saying this. He didn't physically pay them, and he did not, and there was no intent for those men to have sex with Diddy. Under the properly cabined definition of prostitution, the evidence was insufficient to prove that Mr. Combs transported anyone for the purpose of prostitution. Mr. Combs was not a commercial purveyor of prostitution. The evidence showed he transported the escorts or entertainers and his girlfriends interstate so that they could enjoy sex together while he observed. Even assuming Combs was paying for sex, he was paying for these performances, not to participate in them directly. Interesting argument. The videos of the freak-offs and hotel nights and the testimony of several witnesses make clear Combs observed but did not participate in these live shows. Daniel Phillip, one escort, explained that his first such meeting, Ventura told him that, quote, Combs wasn't going to try to touch Phillip or anything. Transcript, I guess, page 249. Every time Phillip met with Miss Ventura and Mr. Combs, Phillip testified, The purpose of the meeting was to have relations with Cassie in front of Mr. Combs. Sheree Hayes, the others testifying in court, said he had similar experience during the 8 to 12 times he had encounters with Miss Ventura in front of Mr. Combs. They're going back to the transcripts. 1896, I guess that's line 1896. According to witnesses, Combs enjoyed these performances and would pleasure himself while watching the escorts or entertainers have sex with his girlfriend. And then he would have sex with his girlfriend, and then they put in parentheses, times they loves as well. And then they go back to the transcript. He was nevertheless primarily a bystander to, not a direct participant in these sexual performances with the males. This is why the videos of freak-offs and hotel nights show Combs' girlfriend, but not Combs himself. And then they go back to all the exhibits and the things to show that this is what was happening. Because basically what they're saying is they use the videotape of him being violent towards Cassie. And that's never going to be denied. That's never going to be denied. But they're saying that they use that to then to contort a RICO charge, which there clearly was drugs. They picked up drugs. They clearly had guns. They picked up guns. They clearly had the baby oil and the Astroglide, which is not illegal, by the way. And the only thing that I see that they had in regards to the weaponry is that they had one or two F-14s that had the serial number scratched off. However, the defense did put forth the argument that all of these weapons that they said that were in a secure area, and that they were accessed by the security. If I can remember all of that. Child, it was so much. But if someone has the transcripts, and they can let me know. Because child. So their argument is that the Mann Act does not cover him. The Mann Act doesn't cover someone who is watching other people have sex. He never transported them for the intent of having sex with him. This is what their argument is. And I'm wondering if the prosecution is saying a lot of people who transport people for the intent to have sex may not be having sex with them. They are having sex with Johns. And so therefore, I don't know if they're considering Cassie the John, because Cassie clearly would be the John. Jane would clearly be the John. What would they're saying that he doesn't have to. If he's there, or if he did the transporting and sex happened, and knowing these people that they understood the intent that they were being transported for encounters with Miss Ventura. I don't know. This is an interesting argument. Miss Ventura would testify that very early in their relationship, Combs explained the concept of voyeurism, which would involve him observing Ventura having sex with someone else, and there's transcripts. In turn, she would tell the escorts before the freak-offs that Combs was into something called voyeurism, and he liked to watch with her doing it with another person. Again, this is going to be interesting with the other lawsuits that have been filed, because again, they're saying that he participated in towards those other lawsuits, that he was the one participating, and that there were other people to participate as well. They're saying that that is not what his quote unquote kink is. He's a voyeur. He likes to watch. I think they call them cucks. Y'all let me know down in the comment. But someone who likes to watch other people have intimate physical relations with their either their spouse or their girlfriends or something like that. Here it is right here. Jane testified to the same pattern of Combs observing her watching with other men, although she did not describe it as voyeurism per se, but rather Combs being a cuck. There it is. A man who's in a relationship with a woman and he's turned on by watching his woman have intimate relations with another man. This distinction between participatory sex and voyeurism is typically irrelevant in Mann Act cases. As explained, the statute's drafters targeted pimps and traffickers whose prostitutes vulnerable women by offering them up to customers. And DOJ policy since the mid 20th century has been focused on such cases, along with situations irrelevant here involving coercion or minors. But this is one of the extremely rare cases in which the statute is being applied against a paying customer, a John rather than a pimp. Combs was convicted of paying for and transporting individuals for the purpose of physical intimate relations to be performed as part of his personal intimate life. That is not prostitution, properly understood, and he's therefore entitled to an acquittal. There was insufficient evidence that Mr. Combs transported anyone with the intent to engage in prostitution, even if it include any sex for money. Even assuming argendio that the word prostitution covers all situations in which someone is paid money to have sex, the evidence was insufficient to prove Mr. Combs had the requisite mens rea. The government's proof failed to establish that Mr. Combs transported Miss Ventura, Jane, or any male escorts or entertainers with the requisite intent to engage in the prostitution. To provide intent under 2421A, the government must establish that the dominant purpose of the travel was to engage in the prostitution. This specific intent must coincide with the actus reus of crossing state lines. Thus, the government must prove that at the time of the interstate travel, Mr. Combs intended that Miss Ventura, Jane, and an adult male would engage in the prostitution. At trial, however, the government's evidence as to Mr. Combs' intent was wholly lacking. It presented argument based on mere speculation or guesswork and did not present any evidence that Mr. Combs intended anyone to have sex for money. The evidence did not reveal any understanding on Mr. Combs' part that the transportation was for purposes of having sex for money. To the contrary, the proof showed that Combs hired the service of legitimate escorts advertised through lawful businesses offering male companionship in exchange for a fee, usually a predetermined rate. Miss Ventura testified that she found escorts through an escort service called Cowboys for Angels, which had escorts in all the major cities in the U.S. Ventura communicated with Guerin, an owner of the Cowboys for Angels, to arrange for the escorts. And they talked the transcripts and they talked about the evidence presented. Combs also corresponded with other Cowboys for Angels representative included Bridget, who referred him to the company's website regarding individual escorts he might hire. And this is in the part of the transcript 7046 through 47. Bridget and Combs even discussed rates. The two spoke about escorts, interstate travel, and Bridget made it clear payment could be by cash or via apps like Venmo. Bridget advised that the company has to dot every I and cross every T to make sure that we stay within a specific guideline to be clear about what the agency offers and sells. She made it clear to Combs, our agency provides time and companionship. You're paying for the gentleman's time. Thus, she was contractually obligated to the rates on the website for each person, as that's the rate we agreed on when they signed me as their agent and at each renewal. They talk about Cassie going to get the escorts from a service called Hunkamania. No evidence shows the men were engaging in anything more than mere performances as opposed to prostitution. And they go on and on and on and on. Again, this is an interesting argument. Says here, upholding the conviction would violate the First Amendment. The evidence at the trial showed that during the freak-offs and the hotel nights, Mr. Combs directed and recorded live performances that he later watched with his girlfriends. The trial record thus demonstrates that Mr. Combs and his girlfriend arranged these get-togethers not just for the voyeuristic purposes of arousal and gratification, but also to capture a performance on video in a manner similar to an adult film producer. The Mann Act cannot be enforced in these circumstances without violating Mr. Combs' First Amendment rights. Paying people to film them in performances is protected by the First Amendment. And they go over the decisions and things like that. Let's see. And we go on and on and on and on. They've got some interesting argument. Again, we're not going to read all of this, but again, they've got some interesting arguments. At a minimum, a new trial is required due to spillover prejudice from evidence that would have been inadmissible had the Mann Act count been tried alone. So they're saying that because of that RICO charge and everything that was added, all of that information prejudiced them. So now they want a retrial with just the Mann Act counts because he was acquitted of the other stuff. They want a new trial so that they can go over all the stuff in regards to the Mann Act and the Mann Act alone. And that's basically, just want to make sure that I don't see any other. The evidence on the surviving counts was not strong. The third factor is that the strength of the government's evidence on the Mann Act, as explained above, was thin at best. So they just don't believe that it is. So let's go over what their conclusion is. As the foregoing reasons, the court should either grant a judgment of acquittal or, at minimum, a new trial in which only evidence relevant to counts 3 and 5 is admitted. So again, their argument is there was insufficient evidence that Mr. Combs transported anyone with the intent to engage in prostitution, and that's when they started talking about the voyeur portion of all of that. They say the Mann Act doesn't prescribe to Mr. Combs because he lacked the commercial component of it, and they went over all. They even pulled out. They even pulled out the Department of Justice manual stating that those, even though the Mann Act covers them, the DOJ does not usually prosecute those cases because of the lack of a commercial element. They're saying there was insufficient evidence that he transported anyone with the intent to engage in the prostitution because he wasn't the one engaged in the intimate relations of the physical kind. He wasn't involved in it. They're saying that, and so number 2, upholding the convictions would violate the First Amendment laws, and they go into what they believe that how his laws were violated. And the last one, bullet point that they talked about was at a minimum he needs a new trial and just to cover the Mann Act. So we will see, y'all. We will see what they're going to do. No, he didn't make any money from it. Hey, Flavio, he didn't make any money. He didn't make any money, and that's what they're saying, that there was a non-commercial thing. And also, he's saying that he wasn't the one that participated in the act. He just watched it and filmed it. And all of this was for personal use. And so, therefore, they got the escort off a legally off a legal website, and they paid for the time. Now, if the people wanted to engage in it, it wasn't they weren't made to do it. If they wanted to do it, they were consenting adults at that point. But they said that they paid the escorts for his time. They gave him tips for his time. So what do y'all think? Do you all think that this is going to hold water? Do you think he has a I don't think that the judge is going to acquit him. I don't see that. But as you all, if you watch my other video, and go back and watch all those videos, I did say that there are now whispers up in the White House about President Trump possibly pardoning Sean Combs. So I'm wondering if they would save face and just try him under the Mann Act. Or is the judge just going to disregard that and go ahead and sentence him? Again, the prosecution wants him sentenced to 51 to 60 something months, and I think that is probably 3 to 5 years is what they're wanting. The defense wants 24 months in time served, because by this point he would have served half his sentence. He probably would have to serve another 3 or 4 months and then he'd be gone. And that's what they're looking at for the judge to do. So I don't know. The judge having to look at this and to review this is going to be interesting. So they filed it on July 30th. So the judge has 2 months to rule on this before the October, I think it's October 3rd, before the October 3rd sentencing. The judge has all this time to look over that. So we will see. We will see. We will see. All right, people. I've got a busy day today with filming. So I'm going to get all my stuff out today. I am about to, what time is it? I don't know what time it is. In about an hour and a half, I'm going to do another live. We're going to be talking about Gilbert Arenas and all the stuff that's going on with Gilbert Arenas. That case is a lot more involved. It seems like there's a lot more involvement than just the gambling issues, but we definitely will get into that. All right, people, we do this every week. Please like, comment, and subscribe. Please share this video if you care. Y'all, do you think Diddy is going to either get these charges vacated, or you think that he's going to get a new trial? Y'all let me know down in the comments. All right. Please tell a friend, tell a kin, tell a coworker, tell that heifer that you can't stand that I'm over here making these videos. And as always, people, bye-bye.